You know, we've all done it a million times. You click buy, tap your card, you make a purchase. And you think you know what it means to own something, right? Well, the reality is way more complicated and honestly kind of surprising. Today, we're going to pull back the curtain on that hidden legal moment when a purchase actually becomes yours. So let's just dive right in with a scenario that I'm sure has crossed your mind. You've just ordered that brand new laptop you've been saving up for. You get the shipping notification. Awesome. But then disaster strikes. The delivery truck crashes, and your laptop is totally destroyed. So who's on the hook for that loss? Is it you, or is it the company you bought it from? The answer is probably not what you think. Don't worry, we're going to solve this mystery together. First, we'll break down the huge difference between owning something and just, well, having it. Then, we'll get to the golden rule, the one principle that governs every single sale. After that, we'll pinpoint the exact moment ownership legally jumps from them to you. And finally, we'll look at some really wild special cases that kind of turn the rules on their head. Okay, so before we can even touch our laptop mystery, we need to get one fundamental difference straight in our heads. And that's the difference between owning something and simply having custody of it. This is such a simple idea, but it is so powerful. Property. That means you are the legal owner. Your name is on the title, so to speak. Possession, on the other hand, just means you have physical control of it. You know, think about a delivery driver. They have possession of your package, but they don't own it, right? They don't have property in it. And here's the key. These two things do not always go together. Let's move on to what is hands down the most important principle of all. This is the big one. This is the concept that directly connects ownership to who has to pay up if things go wrong. And here it is. This is the golden rule. You ready? Unless otherwise agreed, risk follows ownership. It means that whoever is the legal owner of an item at any given moment is the one who bears the risk if it gets lost, stolen, or destroyed. It doesn't matter who's holding it, where it is, or if it's been paid for yet. If you own it, the risk is yours, period. So why are we obsessing over this one single moment in time? Well, because pretty much everything hinges on it. It determines who has to pay for our smashed laptop. It decides who has the right to sue the trucking company that crashed. It even affects what happens if the seller goes bankrupt after you've paid but before they've shipped your stuff. Knowing this stuff really puts you in a much stronger position. Okay, so this brings us to the million-dollar question, doesn't it? We know why the moment of transfer matters so much, but when does it actually happen? Let's crack the code on when ownership really passes from the seller to you, the buyer. So the law basically splits everything you can buy into two big buckets. First, you've got specific goods. Think of a unique piece of art, a particular used car, or as our legal source hilariously puts it, this specific horse. It's one of a kind and agreed on from the start. Then you have unascertained goods. These are generic, like 20 bags of sugar from a warehouse that has thousands of them, and the rules for these two are totally different. Now, for specific goods, the rule can be a real shocker. Let's say you agree to buy that specific horse, and it's all ready to go. The instant you make that deal, the very second the contract is made, the ownership passes to you. So if that horse tragically dies overnight before you've even paid or picked it up, the loss is legally yours. Ownership passed instantly. Wild, right? But for unascertained goods, like our laptop from a giant warehouse, it's a two-step process. First, the seller has to ascertain the item. That just means they have to go and pick out your specific one from all the others. Then comes step two, unconditional appropriation. This is the moment the seller irreversibly assigns that specific item to your contract. It's the point of no return, like when they put your laptop in a box and slap a shipping label with your name on it. Let's look at an old school case about some sugar to see how this works. A buyer ordered 20 huge containers, hogsheads, of sugar. The seller filled up 16 of them, set them aside just for that buyer, and sent a note saying, hey, they're ready. But before the buyer could come get them, they were lost. So what did the court say? Yep, too bad for the buyer. By filling them up and letting the buyer know, the seller had appropriated the sugar to the contract. Ownership and all that risk had already passed. All right, now for the fun stuff. In our final section, we're going to look at some fascinating twists and turns in the law. We're talking everything from global shipping to weird situations where someone who doesn't even own something can actually sell it to you legally. When you're shipping things across oceans, contracts use special terms to define exactly when that risk transfers. You might see FOB, which means free on board. For the seller, their job is done, and your risk begins the second the goods are literally placed on board the ship. With a CIF contract, the risk transfers to you as soon as the goods are shipped, but, and this is the key, the seller has to buy insurance to protect you while it's on its way.
Okay, here's another fundamental legal principle, this time in Latin, nemo dat quod non habet. It just means no one can give what they have not got. It sounds simple, right? If you steal a watch, you can't legally sell it because you were never the true owner. But what if I told you there are some major exceptions to this rule?
And this is where the law gets really interesting, usually to protect an innocent person who had no idea anything shady was going on. For example, if someone leaves their car at a showroom just to be displayed, and that dealer wrongfully sells it, the innocent buyer can actually get good title. Or check this out, a con artist tricks someone into selling them a camera. Before the original owner can void the contract, the con artist sells it to you. Well, in that case, you, the innocent buyer, might just get to keep it. So let's bring it all back home. After everything we've talked about, what about our destroyed laptop? Who is on the hook for that loss?
Well, it all comes down to that word we learned, appropriation. Your laptop was an unascertained good, one of many in a warehouse. The moment the seller picked out one specific laptop, put it in a box with your address on it, and handed it to the delivery company, that's the moment they unconditionally appropriated it to your contract. In that instant, ownership and risk very likely passed to you. That's why that shipped notification is so important. It's basically proof of the exact moment you took on the risk.
So, now you know. The next time you click that buy button, remember that ownership isn't just a transaction. It's a very specific legal moment in time that determines who bears the risk. It's definitely something to think about the next time you're staring at that tracking number, just waiting for a package to arrive. Thanks for tuning in.